Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 251 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues, we provide advice and assistance to both employers and employees on all aspects of employment law. If you would like to learn more about the services that we provide to both businesses and individuals, please don't hesitate to get in touch. I'd be happy to have an initial free conversation with you to discuss anything that you're concerned about, any questions you might have, or if you're just looking to get some help in relation to your own situation. You can email me. My email is alison@realemploymentlawsadvice.co.uk, or you can call our office on 01983 897 003. And my colleagues will be happy to arrange a time for a call back. So this is episode 251 of the podcast, and I'm recording this at the middle of July 2025, and in August 2025 it will be 11 years since the podcast started, so we've been going for quite some time. And in this episode of the podcast I'm going to be talking about constructive unfair dismissal, and this is the first in a short series covering constructive unfair dismissal in a bit of detail. So, without further ado, I'm going to get into this week's featured content. Now, as I said, I'm going to be talking about constructive unfair dismissal over the next few podcast episodes, just to give you a bit of an overview about what constructive unfair dismissal is. And one of the reasons for this is because it's something that is often misunderstood in relation to employment law, but is also something that happens more common, in my experience, than unfair dismissal. So when we're contacted by employees who are having problems at work, quite often the claim that you identify most in relation to those discussions is constructive unfair dismissal. And as I said, it's something that comes up fairly often, so I thought it would be useful to cover off exactly what it is. So now, in relation to constructive unfair dismissal, what I would say is that it's something that has evolved through common law and case law in order to ensure that the laws in relation to unfair dismissal are effective. So as we know, it is important that an employer has one of the 5 fair reasons for dismissal of an employee. And if they don't, an employee has a claim for unfair dismissal. So in a situation where the employer takes proactive action to terminate the employment of an employee, they may have a claim for unfair dismissal. Now, in a situation where an employer doesn't have a fair reason for dismissal, or doesn't want to run the risk of a potential unfair dismissal claim, then they could, of course, behave in a way which is so bad that the employee has no choice but to resign. And this is where constructive unfair dismissal comes in. So you imagine a situation where you didn't have a potential claim for constructive unfair dismissal. Employers could get round an unfair dismissal claim by simply behaving in so badly that an employee has no choice but to resign, and therefore the employee would resign and it wouldn't be unfair dismissal. So constructive unfair dismissal is something that's developed over time. And so it's different to unfair dismissal. So with unfair dismissal, it requires an express dismissal. So that is where the employer takes steps to terminate the employment contract. So with or without notice, they terminate the contract. Constructive dismissal occurs where the employee resigns in response to the employer's conduct that has amounted to what we call a repudiatory breach of contract. So this is where someone has behaved, so the employer has behaved sufficiently seriously to be regarded as repudiatory, so that is they are no longer bound by the terms of the employment contract. So they've acted so badly that the employee has no choice but to resign. So that is constructive unfair dismissal in summary. Now, in order for an employee to claim constructive unfair dismissal, they have to resign in response to that breach of contract. And so you can't bring a claim for constructive unfair dismissal and remain an employee. You have to actually have resigned in order to bring that claim. And the employee must resign promptly in relation to the breach. So if an employee remains employed for a long period or even for a period of time after the breach, then they may no longer be able to claim constructive unfair dismissal because they will be deemed to have accepted that breach. Now, this is something that employees often overlook, not necessarily because they intend to, but rather either they don't understand the law in relation to constructive unfair dismissal, or what is most common is people are worried about leaving their employment and putting themselves into a position where they have no job to go to. So quite often things will happen at work, they will go on, it will be bad for the employee, but they won't actually resign because they can't afford to, and they continue to work, and then later on wish to take action in relation to that. And if there has been a significant period of time between the breach that you're alleging and your resignation, it will be very difficult to pursue that claim because, as I say, you would be deemed to have accepted that breach by continuing to work. So there are several key elements in relation to constructive unfair dismissal, which I'll run through. The first is there has to have been a repudiatory breach on the part of the employer. So this could be an actual breach of contract or an anticipatory breach, so where the employee anticipates the employer will breach the contract, and it can also arise from a series of acts rather than a single one. Now, in all cases, the breach has to be sufficiently serious to justify the employee resigning. The second part of constructive unfair dismissal is the employee has to resign in response to that breach. So as I was saying previously, employee has to resign in response to the breach of the contract. They can't remain an employee. And then the next point is that the employee must not delay too long in accepting the breach. So they have to resign promptly, as I was saying. So there's three elements. There has to be a breach, the employee has to resign, and they have to do so promptly. Now, as I was saying right at the beginning, in relation to constructive unfair dismissal is something that has developed through case law and through the common law over time. And so, as you'll imagine, there have been lots of cases in relation to the breakdown of essentially what constructive unfair dismissal is and the times in which an employee can bring a claim. Now, the leading case in relation to constructive unfair dismissal, and for anyone who's listening who's ever done a law degree or been a law student or done any kind of law course, you will have heard of this one because it is a case that everyone talks about in relation to employment law, and that is Western Excavating versus Sharp. And this is a case from 1978. So, the facts of this case are, briefly, that Mr. Sharp was suspended without pay for taking time off after his employer had refused permission for him to do so. His suspension without pay created financial hardship for Mr. Sharp, and his request for an advance on his holiday pay or a loan was refused by his employer, Western Excavating, and he subsequently resigned to access his holiday pay immediately and then claimed constructive dismissal. Now, the key point of the case was whether the employer's actions constituted a fundamental breach of contract. So the key points to note in relation to this is that Mr. Sharp was suspended without pay because he'd taken time off without permission. He'd been put in a financially difficult situation. He'd requested assistance from his employer, which was refused, and then he resigned so that he could access some pay immediately. And the key issue in relation to this case was whether the employer's conduct amounted to a fundamental breach of the employment contract. Now, in addition to that, the court also considered whether Mr. Sharp had resigned soon enough after the breach to be able to claim constructive dismissal. And this case, as I say, sets the foundation for the constructive dismissal principles. And in the case, the court emphasised that there must be a fundamental breach of contract by the employer, so it must be fundamental, and that the breach must go to the root of the contract, so as to breach trust and confidence, and the employer must resign, as we say. And the leading judge in this case, Lord Denning, had said, if the employer is guilty of conduct which is significant breach going to the root of the contract of the employment, or which shows that the employer no longer intends to be bound by one or more of the essential terms of the contract, then the employee is entitled to treat himself as discharged from any further performance. If he does so, then he terminates the contract by reason of the employer's conduct and he is constructively dismissed. So it is a leading case as it sets out the real principles in relation to constructive dismissal, as we've been saying. Now, you will have heard me mention there in relation to the breach of trust or confidence. And the principle of trust and confidence came about as a result of a case called Malik versus BCCI from 1997. And the breach of the mutual trust and confidence obligation is something that is often relied upon in relation to constructive dismissal. So when we're talking about a breach of contract, it can be a breach of an express term of the employee's contract. So, for example, the term that says that the employer will pay the employee for the work that they do is an express term of their employment contract. But also in relation to contracts, there are a number of implied terms. And this case, Malik versus BCCI, is the first case that really introduced the principle of this implied term of mutual trust and confidence. So the facts in the case of Malik versus BCCI are rather interesting, and it involves two former employees, Mr. Malik and Mr. Muhammad, who were employed by the Bank of Credit and Commerce International, so BCCI. The bank collapsed due to widespread fraud and illegal activities, and after being made redundant, Mr. Malik and his colleague claimed that their former association with the employer, despite their own innocence, had created a stigma that severely hindered their ability to find new employment in the financial sector. So the fact that they had worked for this company that had collapsed due to fraud and illegal activities was having an impact on their ability to find future employment. They argued that the bank's corrupt practices had breached the implied term of mutual trust and confidence in their employment contracts, leading them to have financial loss due to their diminished job prospects. And the key part of their claim was that the employer's breach of contract had directly led to their financial loss due to the difficulty they had in finding new jobs. And in this case, it wasn't centred around constructive unfair dismissal because, of course, they had been made redundant, but rather it was around whether they could be awarded damages for injury to reputations, so the stigma that resulted from what they allege was a breach of the implied term of trust and confidence in an employment contract. And in this case, it was a House of Lords decision. They ultimately ruled in favour of the employees and said that there had been this breach of an implied duty of trust and confidence, which had caused them loss as a result. And so Mr. Malik and his colleague were successful in their claim. And so what this means for employers is that while this isn't a case directly related to constructive unfair dismissal claim, it does present this implied duty on all employers to behave in a manner which is fair and reasonable and not to undermine this mutual trust and confidence. So employers mustn't behave in a manner likely to destroy or seriously damage the relationship of trust and confidence. So the employer must not, without reasonable and proper cause, act in a way which could damage that. And so as a result, many employees now rely on this implied duty of trust and confidence when they are pursuing a claim for constructive unfair dismissal. And in the case of Core versus Leeds Teaching Hospitals NHS Trust from 2018, the Court of Appeal helpfully listed out 5 questions that an employment tribunal would need to ask in order to determine whether an employee was constructively dismissed. So as you can see from those 2 cases, the Western Excavating case set about the foundation for constructive unfair dismissal, and the Malik case brought about the concept of implied trust and confidence. So when you're determining as an employee or an employer whether there is a claim for constructive unfair dismissal, it's important to have a look at what the decisions say about this. And there has been a helpful decision of the Court of Appeal, which was from 2018, and this is Core versus Leeds Teaching Hospitals NHS Trust, in which it set out 5 questions that you should ask in order to determine if an employee has been constructively dismissed. So if you are going for a case or you're considering whether you have a claim for constructive unfair dismissal, I would suggest that you go through each of these points in turn. The first question is, what was the most recent act or omission on the part of the employer which the employee says caused or triggered their resignation. So when we're talking to employees who have a potential claim for constructive unfair dismissal, we ask them to set out in a timeline what's happened and then what exactly is it that triggered you to resign. And we just simply ask that question. And you should ask that question of yourself if you're an employee in this situation. So what is it that has tipped me over the edge that I'm now going to resign, or I have resigned? So that's the first question. The second question is, has the employee affirmed the contract since the act? So again, now if you're thinking about it and you have waited, so let's just say you either, couldn't resign because you couldn't afford to, or you've been off sick, and you're looking back and you're thinking, actually, the last act that I would be relying on as a breach is 4 months ago, then it's possible that you have affirmed the contract. So have you continued to work or remain employed since that last act that you are relying on? And then the next question to ask is, was that act or omission by itself a repudiatory breach of contract? So was that one thing enough to amount to a significant and serious breach of the contract? And if you don't have that last act as being the last omission as being the repudiatory breach, then you need to ask yourself whether it was part of a course of conduct that continued over several weeks or months. So is it part of a series of acts or omissions, so which you have been subject to? And again, this is something that happens quite often, is that things go on for a long period of time, and it's not just one big thing, but lots of things that mount up over time. So viewed together, has it amounted to a repudiatory breach of the implied term of trust and confidence? So that's the fourth question. And then finally, the fifth question is, did you resign in response or partly in response to that breach? Now, one of the issues we find with constructive unfair dismissal cases is that employees will resign because they have got a new job. Now, it doesn't necessarily take away from the fact that the employer before has been in breach of contract, but if they haven't resigned as a result of that breach or series of breaches, and they've actually resigned because they've got a new job, then again, this will be something that will be difficult to show to the employment tribunal if you're pursuing a claim for constructive unfair dismissal. So just to recap in relation to constructive unfair dismissal, it's important to note that in order to pursue a claim for constructive unfair dismissal, an employee has to resign in response to a significant or serious breach of contract or a series of significant breaches of contract. And one of those things could be an implied term that's implied into the employment contract in relation to the obligation of mutual trust and confidence. So not only can there be a breach of a express term of the contract, so something that's agreed or written down, but also the implied term of trust and confidence. And this is the thing, as I said, that most employees will seek to rely on in relation to constructive unfair dismissal, particularly if they're looking at a series of acts that result in what we call a last straw that leads the employee to resign. So this episode of the podcast is a rundown of the key elements of constructive unfair dismissal. In the next episode of the podcast that will be coming in 2 weeks' time, I will be covering some examples from case law of times when employees have been successful in relation to claims for constructive unfair dismissal, including examples of the key areas where we find as practitioners that employees are successful in a claim for repudiatory breach of contract, so constructive unfair dismissal, or where we see that there are things happening fairly frequently. If you have any questions in relation to this episode of the podcast, please don't hesitate to get in touch. If you have a scenario that you're working through either as an employee or employer that you'd like to talk through with a solicitor or lawyer, then we can arrange that on a free initial consultation. You can contact me by email, alison@realemploymentlawadvice.co.uk to set that up, or alternatively you can call my office on 01983 897 003. And my colleagues Kathy and Annabelle, who answer the phones, will be happy to set you up with an appointment with a lawyer as soon as possible. Thank you so much for listening to this podcast episode. I know that many of you listen regularly and that you do subscribe and leave comments, so thank you very much. If you're listening to this podcast and you find value in it and you are on TikTok, if you have a TikTok account, then I'd be grateful if you go over and like the page. Is it like? Subscribe or follow, whichever it is in TikTok. It's at Employment Lawyer, and I put loads of videos on there, updates and things, particularly for employees. So it would be great if you could go over and follow or like any of the videos on there. Thank you so much for listening to this week's episode. I hope that you have a fantastic 2 weeks, and I look forward to bringing you another episode delving into constructive unfair dismissal in 2 weeks' time.
Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.